So, dear colleagues, the second speaker of today is Mr. Tarun Khurana, and he'll be taking up the topic of IP analytics, something which has caught up very fast. Let's see how it is faring in the domain of IP. Mr. Tarun has over 17 years of experience in a broad range of IP subject matter. He is the co-founding partner and patent attorney of Khurana and Khurana and of its patent research and IP asset management. This firm is IIPRD. He has a strong experience in patent drafting in the domain of computer networking and has drafted over 3,000 applications in aggregate till date. He is a regular speaker at numerous institutes and corporates, including international conferences such as GIPC, WIPA, CII, FICCI, along with at entities such as NTPC, Indian Oil Corporation, IITs, TIFAC, DIT, CSIR, Moser Bayer, IIM Lucknow, ASSOCHAM, Managing Intellectual Property, Indian Oil Corporation, NALSAR, ONGC, Delhi Technical University, and Tata Group of Companies. So I see Mr. Tarun, you have a wide and a vast, diverse experience of sharing your insight into different areas, right from academics to corporates to whatnot. So with so many feathers to your cap, I hand over this session to you. So please go ahead.
All right. Thank you very much, ma'am, for having me for the session. I come from a litigation and patent prosecution and more legal strategic background. I did my computer sciences engineering from Pune and then did my master's from BITS Pilani thereafter. So I sort of do more techno-legal mandates. IP analytics is something that the firm does at a very extensive level, but I don't personally practice significantly in the space. But I obviously, having run the practice for about 13 years, I have sufficient exposure on various issues of IP analytics, which I thought I'll share, and I'm happy to answer either intermittently or at the end of the session at your convenience. Very quickly, IP analytics has a very, very broad spectrum to it. There is no defined boundary of how you define IP analytics. It is basically any exercise that involves processing of data or content from various patent resources to achieve one or more business objectives. I have mentioned few of the objectives, but again, these are not exclusive of each other. There could be a combination of two, there could be a combination of three, and you could sort of obviously combine parts of these as well, but just very high level objectives could include when, for example, a company is entering into a new R&D tech space, they want to understand where is there an opportunity to develop a patent portfolio or an IP portfolio, where is there a blockage, which means that a space which is so heavily populated with patents that even if they come out with a product, it is likely to infringe on multiple patents, which are either granted or in the published space. Now, telecom is, for example, one very heavy and dense area where there are numerous standard essential patents, and any product like a switch or a router or any eNote B or a base station that you might want to sort of deploy or start manufacturing from a hardware standpoint would require you to comply with certain standards which have been set out in the telecom space. And therefore, when you start doing landscapes in such areas, or when you start doing analytic exercises in such areas, you'll see that there is a heavy blockage by virtue of you not having the freedom to operate. And when I say freedom to operate, it is also called, say, the FTO, which essentially would mean that are you likely to infringe on some patents when you commercialize your own products? And therefore, IP analytics helps you to understand, is there a white space in a particular region of, for example, if you're making something with polyethylene and you're wanting to be in the medical device space, now you want to see what all companies are doing work in polyethylene, what kind of patents are they filing, what is the specific technical problem that they're trying to solve. And therefore, analytic exercises would help us understand whether there are gaps for us to explore purely from a commercialization and IP infringement perspective, or whether it's a field where, irrespective of how good my product is, I am likely to infringe. Now, for example, again, in the razor blade category, it may feel like there are only one or two companies, but Gillette, for example, is so heavy in the patenting space that there is very little scope for you to come out with a product which would essentially be not infringing on one of their patents. The concept of reverse blade, how angles of the blade are configured, how the rotors within the blade are sort of structured, whatever that technology might be, from saving the skin to get cut, everything is sort of very heavy on patents, and therefore is likely to sort of block you. Other objectives could essentially be market research. Now, for example, if you wish to license your patent, or if you have a patent, or if you want to buy a patent so that you can go ahead and start commercializing, then you obviously have to understand what is available in the market, what are granted patents, what is the scope of those patents, because just because you have a patent which is granted does not mean that you have luxury in the world to introduce that product, because when you develop a product which is mapping to a particular granted patent, it is possible that there is a preceding granted patent which is also live and existing, and which instead may get infringed upon commercialization of your product. And therefore, it is imperative for us to understand where there is an opportunity. Is there a business intelligence mandate there where I can do the screening out, do this analysis of so much of thousands of patents that are in a particular space, so as to identify whether I can buy some, sell some, commercialize some, whatever, again, as the objective may be. The second point, as I mentioned, is could be to design your R&D investment strategies. You don't want to do your R&D in a space which is already explored quite well, and therefore it's sometimes better to understand which patents are granted in the US, and those applications may not have been filed in India at all. And with intellectual properties being territorial in nature, it is very much likely that you may just simply copy a technology which is granted in the US and save all of that R&D time that you would have otherwise invested to sort of come to that level where that patent is already helping you. Now, I work in the diamond manufacturing space significantly, for example, and there are CVDs which are artificial diamonds, and there are so much of wealth of knowledge which is already available, not only in the form of non-patent literature documents, but also patents, where they talk about HPHTs, high pressure, high temperature techniques, at what pressure, at what temperature, what kind of mapping will give you what kind of output. All of that has been so well researched that if you do not know what's already out there in the patent space, then you will probably do a significant amount of time investment in exercises which otherwise could have been easily avoided if you could have just done some analysis of what's out there, and you could have started off from what is out there already. Another very big advantage of doing IP analytics is also competitive intelligence, where we work with tons of companies in the petrochemical space or in the FMCG space, and they want to understand what kind of patents are companies filing, and where are they filing, and what kind of claims are they writing, what kind of potential difficulty can those patents cause to us in the future. Now, for example, HUL would be keeping a very close tab on what kind of patents J&J is filing, for example, because they would, and it's not that patents are filed after the patent products have been conceived. A lot of time, these patents are filed much before the products are actually prototyped and developed and manufactured. So if you keep a close watch on who's filing what, and if you have very specific competitors that you want to worry about, then you can actually read their patents. They get published fairly quickly. So by virtue of that, you would in advance know what the strategy of those companies is, what kind of products are they going to bring up with, and then you can either increase or speed up your bring to market so that you can launch before them, although they filed a patent application before you did, or you can sort of make sure that your products are not infringing on their patents. So competitive intelligence becomes an extremely important tool for various companies, not only in the spaces that I talked about, but anything, in the television space, in the digital space, large companies like Google keeping a track of what Amazon is filing from an e-commerce standpoint, or even from other platforms, what kind of delivery mechanisms are being filed. In the network security space, for example, Fortinet would like to keep a close tab on what any other entity in the network security space is doing, and so on and so forth. Also, to identify potential licensing opportunities is another big advantage, where you have a patent which is granted, for example, in say a molecule or an antiviral in the COVID space, and then you want to understand which companies can you actually reach out to license or sell the IP. And therefore then in such cases also analytic becomes very critical deal, because otherwise if you're just shooting in the air and writing emails and reaching out to companies which are hundreds in nature, they may not really even be keen or interested because they're not working in that space. But if you do a thorough investigation and understanding of analytic mandates, then you can identify which companies are actually working in that space, because companies working in a particular technology area are far more likely to buy or in-license a technology that you may possess compared to companies that may not even want to enter into that or have not even started doing any R&D. So all of these are objectives, again, depending on what company wants to achieve what objective or a combination thereof, you would sort of get these analytic exercises done. There are various steps to it. Again, what I've explained here as step 1, step 2, step 3 are merely one way of doing it. But again, there could be hundreds of different combinations, and companies could do it differently at their own in their own desired format or style. But essentially, the first step starts off with the defining of the scope of analysis of what the objective is. Are you trying to, for example, Adidas wants to keep a tab on what patents Nike is filing. Now, if that's the focus, then obviously Adidas would not want to read its own patents, would not want to do any analysis apart from focus on Nike. And therefore, it's very important for you to know what your objective is. So that is what would help you keep your entire analytics exercise concise. And then based on your objectives that you've understood, you define the scope of analysis. And based on the scope of analysis, now, for example, Nike does hundreds of things. They're in the footwear, they're in the clothing, apparel, various other weather-controlled garments and stuff like that. So if you're only wanting to study their shoe segment or in the footwear segment, then you obviously have to restrict your technology domain to that level. Otherwise, you're again reading data which is of no contribution, and the final analysis would also get diluted because of that. So you will have to define the technology domain that you want to cover. You have to focus on the countries, because that's also important. If you're a US company, and if there are companies like Chinese entities which are filing patent applications in China, and they have a very, very heavy, dense portfolio in China, it would have no bearing from a freedom to operate standpoint doing such an analysis if your sole market is in the US. Same goes for India. If 98% of diamond manufacturing, for example, happens in India, I don't want to be too keen on what's happening in South Africa as regards the patent portfolio is concerned. I may be, but I may not be as well. And therefore, country coverage becomes an important parameter for me to consider on such exercises. Time period of evaluation is also very critical, because the last 5 years will give you more relevant material or more relevant data to understand what kind of portfolios are being developed. But if you do an analysis of Microsoft as a company for the last 10 years, the data that you will get may indicate a lot of technologies that have been outdated already by virtue of the speed of technology and the manner in which they're brought to the table or to the market. Time period therefore plays a very critical role. You may just want to do it for 6 months or 1 year or 2 years if you want to be very contemporary. But if you think that this technology that we are talking about, maybe a particular type of image compression, that would have taken 5 years from the very beginning till the end, then obviously 5 years is the horizon. So all of these are parameters which are very critical while starting an analytics exercise, so that we know what our scope of results are going to look like. Now, the type of data is also an important. Are you going to look only at design applications, or only at utility patents, or only at, say, utility designs or utility models? For example, US and India don't have utility models, but in Germany and China, for example, there's another category of IP called utility models. So that's also extremely important for us to understand what kind of data are we wanting to look at. Are we only looking at aesthetic appearances? So only a design is necessary, or if a freedom to operate may get defeated. Now, for example, if you're coming up with a RO water purifier, there may not be many patents of companies like Kent in India. Maybe 5, 10, 15 applications which are core on technology of how reverse osmosis can be further bettered as regards the manner of treatment of water, and maybe alkaline-based water purification mechanisms and all of that. But the majority of their IP is around the design. So even if you tomorrow have a freedom to operate with respect to a utility patent, but you do not have a freedom to operate with respect to a design, which, for example, could be a transparent top or an opaque bottom, of the Kent, then obviously you will get hurdled there as well. So the type of data is also important. All of this would depend on what the objective of the study is. And then claim subject matter. What are you trying? What kind of claims are you looking at? Analysis. Do you even want to look at the claims, or are you only looking at one-dimensional data as to who's filed, where have they filed, which years have they filed, how many have they filed? If those are the bibliographic level data that you are happy with, then probably going into the claims may not be critical. But if your intent is to understand what have they claimed, what is the scope of that claim, how many limitations are there, what would constitute infringement on those claims, obviously you have to look at the claim subject matter. Basis which you then have to define the taxonomy as regards what are your keywords going to be, what are your classifications going to be, and taxonomies are usually multi-hierarchy level. So we start with a footwear. Now then you start with then you say, okay, footwear has multiple components. The sole, the laces, the upper half of the shoe, and then within that also you define further. So sole can be of multiple types. Again, the top half could be of multiple types. And those types could be, again, multiple attribute based. It could be material based, it could be technology based, it could be functional based. So all of those will get defined as regards taxonomy of analysis is concerned. And therefore, taxonomy also becomes an important thing to define in the scope of the study. Once we've defined the scope, it's important to run the taxonomies that we've identified and through various strings. And therefore, data collation becomes the next step, where we run multiple search logics to extract the required data set from the aforesaid databases. These databases could be proprietary databases like Questel and Derwent and Thomson Innovation and so on, or could be free databases like Google, EPO, WIPO, and USPTO, and so on and so forth. But the intent of this step essentially is to run variety of strings and then avoid the redundancy. So whatever duplication that comes out, you sort of keep it out and you remove it so that the data set that you have matches exactly what you're looking at. So it matches the exact IPC, CPC, which is the classification of every patent. Every patent can be classified into 2 or 3 or 4 different classes. CPC is the US, IPC is the International Patent Classification System. And therefore, we could have IPC, CPC based searches. We could have keyword based searches. All of those keywords would have been identified based on the taxonomies that you've identified. So once you've run 5, 10, 15, 20, maybe 30 search strings, the data that you get is cleansed from the perspective of removing duplications. And then you have the final data, which, for example, could say, okay, here are those Nike patents which are focused on soles that Nike is using or is proposing to use. They are rubber based. Within the rubber, they are based out of a particular acrylic rubber, and they are only last 2 years old. So it may be 30 patents that you're looking at, it may be 2000, but at least you know exactly what filters have you defined so that the output that comes is the exact data that you want to assess or analyze. And these are the various fields. There are tons of fields in all these databases that we work on. We could do a search based on patent number, publication number, or ranges. So you could say earliest priority date. So you could say, show me those patent applications which are having a priority date from 1st of January 2018 to 1st of January 2020. So all those ranges can be defined by application date, publication date, grant date, inventor name, and so on and so forth. So these are all various fields by virtue of which we can also say, okay, show me those patents where in the claims we are talking about blockchain technology, which is run through a particular type of encryption algorithm. So, that algorithm could be there in the claim, and blockchain technology or the blockchain mechanism to put some cipher codes on the blockchain could be on the other side. So we can do a search based on the claims title, back count of citations. Citations basically are that when you file a patent application, you may refer to many documents in the application which become background knowledge, or say, okay, these are the 10 patents which are in the same field. These are disadvantages of all the patents, and here is my invention. So all the patents that you refer to in a patent application or that the examiner may refer to during the prosecution becomes the citations. So these are the parameters on the basis of which you could run the strings, based on which the final step of, not the final, but the next final step of data cleansing or optimization that happens, where you, as I said, reduce redundancy You run strings where you could, for example, IBM could be referred to as International Business Machines or IBM US. So we have to make sure that the strings are configured such that all possible names of applicants, of inventors, of dates, of IPC, CPC, all those parameters are well taken care of so that we don't miss any data. And that's the whole point of either cleaning the data post or optimizing the data before running the strings. So even the address and the date and the country, there could be numerous. So we want to, for example, one patent application filed in India may eventually have been filed in US and in Europe, but that doesn't make it 3 applications. It is still one family of applications. And therefore, we also have to ensure that, for example, while doing the search, the results that are reported to us are unique families. There should not be repetition. So it should not be that instead of one result, which is the Indian application, the whole set indicates to me 3 results. Because if it does, then my whole analytics that I will run post that will get diluted and will show me distorted data, will show me one extra application in the US and another extra one in the Europe, which may not be sort of the desired way of doing it. We just want to see how many unique applications have been filed by the applicants. And therefore, that level of cleaning or optimization becomes, and a lot of it can also be done automatically. So we have tools, we have softwares which could help us gauge or say that, okay, if you put IBM, all IBM subsidiaries, all IBM companies that they've acquired, full form, half form, whatever that might be, will all be covered in. And by virtue of that, we don't have to do a lot of it, but you obviously have to check and cross-check randomly to make sure that everything is sort of intact. 4th step is the visualization of information. So once the data has come out and you've optimized it and cleansed it, you have to visualize the data, and that could be done across multiple formats. I will share with you some sample charts and reference pointers of how the data can be, and there is no limit to it. There are tools like Tableau or Microsoft Visio or MS Excel or numerous PPTs, and all of that can be used. A lot of them are automatic, so you just feed with them the data and they will generate all the charts, which are just beautiful, and you can sort of use them for visualizing all the data. Post which the final step of actionable insight is done, where we can analyze the information which is being there. This analysis can be done just based on the data or can be done based on the visualizations. Now, visualizations in the first instance will not give you all the data behind it. So if there could be 3,000 applications which may have resulted in the 5 graphs, but those 5 graphs are not going to indicate how many patents have been analyzed, for example, or if it says that, okay, 3,000 or out of the 3,000, 2,000 applications have been filed in China, which are those 2,000 applications? For that, you will obviously have to go back to the data and look at the taxonomies and the classifications that we have done so as to be able to identify how we arrived at those visualizations. Now, having said so, this actionable insight can help us analyze information, can help us identify key metrics based on which the actions and decisions can be taken, can help us determine R&D direction of research, in what way are the competitors going, and what way are we going. Are our patents even mapping to the products that we are launching? So a company in the medical device space, like Philips, for example, they would be very keen to understand, okay, we are filing 5,000 applications a year, but which patents are mapping to what products? And the ones that are not mapping or have not gone beyond to actual commercialization or prototyping, we want just not continue those applications. And therefore, analytics can not only be done on competitors or on third-party patents, but also on your own portfolio to see and make sure that your whole portfolio is accurate and is sort of representative of what you intend to get covered. Anything otherwise would sort of is an extra burden on the cost to the company at large. Also, we can identify the reason-based patent portfolio building. This is what I was mentioning, that you can reason out of why our patent portfolio is being built in that particular way, and you can sort of give reasons to it to the firm management, and also decide the direction in which you want to build your patent portfolio based on the analysis that you've done that comes out of the visualization. So these are the steps usually done from an analytics standpoint. Analytics can sort of be broadly categorized into 3 categories, but I can just pause here for a minute and just wanted to understand if there is any question that I can answer right now, or should we park it till the end? And if I'm going a little too fast, you can let me know, ma'am.
Okay, sure. So, dear participants, if you have any questions from Mr. Tarun Khurana, you can please raise it. raise your queries, or if you have any other thing to address, like a speed or whatsoever. Or should we continue?
Yeah, the speed is perfectly fine. One can continue.
Okay, thank you so much. So, Mr. Tarun, you can continue. Maybe they will ask in the end.
Sure, sure. So, pattern data analytics, again, as I said, can be categorized into three categories. You could just do a one-dimensional bibliographic data analysis, like how many patents were filed in a given year, or you could do an assignee-based analysis. Okay, give me how many patents been filed by Microsoft versus Google versus Apple versus Amazon, for example. Or you can do an inventor-based analysis. Okay, for these 5 inventors, how many patent applications have they filed and when? And or you can do a country-based analysis. So any bibliographic data means that there's no technical analysis being done at that stage. The second could obviously be technical analysis, where they analyze the claims or analyze the abstract, analyze the title, analyze the whole technology domain, IPC, CPC, and so on and so forth. And then third is mixed, where the clients want to understand both. They want to understand which companies had filed, but in addition to that, they also want to understand what kind of patents were there, what limitations were there in the claims, what was the claimed subject matter, and so on and so forth. So all of those things become more technical and therefore form part of the technical analysis. Okay, so some examples of analytics. This is bibliographic database analysis, indicative of how many patents, for example, these companies have filed. So we start with Tessa and Lintech from the bottom. They filed 7, Lintech is filed 8, Nippon is filed 8. Again, this could be in a particular technology area. Obviously, as we see Denka and LG, they filed 25, but that would be in a very narrow field. Maybe in the OLED, within OLED also a particular type of waking up of the LEDs that is their one very specific algorithm. And so this is indicative of, and this will also indicate, for example, are there a number of filings higher than the last year? Or for example, the arrows which are pointing to up will indicate that their filings have grown. Bridgestone, for example, has 32 applications, but it shows a downward arrow, which means that, for example, the number of filings have gone down, and so on and so forth. So these representations can be anything at all and depends on the companies. There is no standard norm here, but depends on who's doing the analysis and what kind of nomenclature are they following. Post that pertains to dissection of patents, applications pertaining to type of rubber, for example. This is indicative of types of rubber being used in a particular application. As we can see, for example, 17% is neoprene, and 14% of patent applications for the type of rubber being filed, maybe in the tires, for example, let us assume this was for tires, are for butyl rubber, and butadiene rubber is 10%, and so on and so forth. So such a graph will indicate to you that of the thousands of patents, what percentage of them used this kind of rubber. And hence we sort of represent the graphs there. Now this may not be very...
Tarunji, I have a question. My name is Dr. D.D. Swai. Can I ask the question? Not a question, a query, with the permission of Dr. Benita.
Definitely.
Yeah. Tarunji, is there any software for the analytics, particularly for this patent and intellectual copyrights?
Yeah. You can use R. You can use Tableau. You can use Tableau is very simple. It is relates with visualization. But R you can only do if you're good in commanding or commands writing, and then of course there is Python.
Okay. Thank you.
So the problem with Tableau is that it's not a patent software, so it will only indicate that you will have to give data to it as input. So, but there are many visualization softwares which are patent oriented. So basically, you just have to run.
Please tell them.
And the Patseer is one of them, for example. There are many of Thomson, which is Clarivate now. So Clarivate also has another. There is a software called Innography. And there are many of them which are patent analytic software. So you just have to run your strings, and the data that comes out of it, they will automatically generate charts for it.
But Tarun, I think Patseer is free. Are the rest also free? No.
No, ma'am, Patseer is not free, ma'am. Patseer is a Pune-based
Patseer is also not free. So if it is not free, that means they have to subscribe.
Yeah. There is no free analytic software in that sense.
Okay, so I'll write Patseer. What else?
There is a software called Innography, ma'am.
I've heard, but this Tableau and all is free. But it is only for visualization with some limitations.
That's correct.
But
So
if you
in the free version will only give you a few features, but we use, for example, the business version. So they have tons of different.
They're already sharing it from. Fine, very fine.
And I can share more later on as well. But basically, you can also go to a website called Clarivate. They also have a number of software. Every large entity on the products on the software product space and the IP side would have a visualization software as well. But I think Innography serves one of the most important purposes. There again, it has an AI orientation to it, so it can automatically gauge what kind of taxonomies are you looking out for it, and sort of automatically generate charts.
Tarun, what about this predictive modeling? Which one does? Because through R we could do predictive modeling. Like one of my computer students, we are working together. We have already done through. We have used Python, but for can these do predictive modeling? I don't think so.
Ma'am, a few of the softwares do, but again, the way they do it,
They are mostly for visualization, as far as I know.
Not really. I mean, the companies which are very deep neck into it, they sort of do a very heavy duty work. They obviously do a lot of modeling internally and generated They have learning models which sort of do learning on a regular basis as regards the kind of charts that you've developed in the past, and sort of learn them in a manner so that they keep on sort of improving. Yeah, but they have features. They'll have to be sort of studied in that sense, ma'am.
Okay, thank you so much. Please carry on.
Yeah, just one second. So these are a few other charts that we've developed again through Tabview. I'm just sort of zooming it up so that everybody can see it better. So these are Chinese companies that we had analyzed for a particular client: State Grid Corporation of China, Beijing, Invisi Power, and so on and so forth. They were more in the electrical space, more in the power generation space. And then this was a chart where we wanted to map which of these entities has filed patents. So these are the taxonomies that I was talking about. One is the technology, hardware, performance, parameters, miscellaneous, and so on. And within technology, then we have inductive coupling, magnetic resonance coupling, others, capacitive coupling, and so on and so forth. So this is a two-level taxonomy that we have created, and we have indicated how many patent applications have been filed by these companies in each of these spaces. So if you were to do it for the technology as a whole, there'll be 15 applications by State Grid. But then we can even go within inductive coupling and say, okay, what kind of inductive coupling mechanism were they using? And therefore, this number will again further get split up. So you can go into as much amount of detail as you wish to. Depending on the count of parameters used, you can also divide your charts based on how many parameters. So it could be a single variable, it could be a two variable. And I can show some values. Single variable could be essentially, for example, a simple count of number of patents in the technical domain, or a count of active assignees, for example. How many companies are there in the EV space, for example? How many inventors are working in a particular type of paper manufacturing sector, for example? So these are all one-dimensional parameters, and therefore they're not indicative of two different ways of doing it. So across how many years? So sooner you would say, okay, how many applications were filed by this company or these companies across the last 5 years? Then it automatically becomes a two-dimensional matter because you're looking at two dimensions. Two-dimensional, again, just to give an example, could be a priority year trend. How many applications across different years, or application year trend? Now, trend will indicate how many applications are filed in 2005, 6, 7, and therefore automatically becomes like that. Now, this is another indicative of number of applications published versus assignees. Now, this, for example, on the left-hand side, C08L is the classification, and within C08L, we have given a second level of classification, which is C08 130. So in this particular space, there were two applications filed. Again, this could be across years, so we would have limited it from 2018 to 19, only for 1 year. And so this indicates that, okay, C08L11-U0, whatever this definition corresponds to, had the maximum number of applications by far compared to all other domains. And therefore, this is how we can do it so this, for example, last classification in C09J indicates the maximum number of applications filed. So you could generate any kind of charts based on the desired material. This is, for example, distribution of patent applications pertaining to hardware. Now, this was in the same report that we had generated this chart from. So we had said, okay, within the hardware, these are the second level of taxonomies transmitter, receiver, control circuit, rectifier, and so on and so forth. And therefore, another indicator would indicate how many of those applications are being filed. So most of them, for example, are in the receiver space, and then there are control circuits and so on and so forth, and transmitter. So this is the distribution from a chart standpoint. Now, this is again a distribution of, we are just sort of showing different kind of representations that we generate. So this is only to indicate this classification. I can just zoom in a little. So this classification H01F is only having 6% of the whole application set in a particular type of product segment. Whereas
Tarun, yes, just sorry to interrupt you. Is it in slide mode presentation?
Yes, ma'am.
Okay, then fine. Somebody's asking, put it in slide mode. It's already in slide mode.
No, ma'am, it's not in slide mode.
Yeah. I have now put it in the slide, but it's just that there's a slight disturbance that comes on my laptop when I put it, but that's okay. Can you see the red thing
now
outside?
It is in slide mode. Yeah, now it is in slide mode. Yeah.
Sure. So this was to indicate the distribution of patents on classification basis.
Yes.
This is another detailed view of technology distribution versus filing date. Now, for example, a particular type of technology, 2010, 12, 13, across multiple years, how many applications are filed will indicate where and at what stage was the filing maximum. The tools that we have obviously also help us to double click on any of these charts, and it will go into the second level of taxonomy. For example, if our first level of taxonomy is the one that is shared here, and within the hardware, there are 5 more taxonomies. When you click on this link of 2018 indicative of 232, we can double click on it and go to the next level of taxonomy that is there within the hardware. So what is that 232 comprising of will also get shown. So all of those flexibilities are there in the final set of tools that we essentially have. Now, this was again we can also generate exploded views where, for example, this is the dissection of patents applications pertaining to liquid composition of a particular ingredient. Now, for example, a particular drug, and how many formats is it being given in a liquid composition versus in a solid dosage form. And then within the liquid, is it solvent based or is it water based? And then you can further take the solvent based to further categorize it. So you can really deep dive into it again and again and again and again, all depending on to what extent of detail do you want to actually go to. So these are some other charts where we have shown country-wise publications. Now, here we can see that Biosense Webster, for example, has 443 applications in Israel and 32 applications in WIPO and in EP 430 and so on and so forth. So obviously this is an Israeli company trying to file applications, but then also it's important to understand that we have to ensure that this should not include families. So it should not be that these 430 applications in EP are a set of these 443. Because if they are, then this has to be very clearly explained in the report that we generate. And that is what is important as regards the representation, because it should not be confusing to the reader of are these 430 different applications or are they the same set of applications out of which this 443 came out. 32 are the PCT applications, for example, and that is how you take it forward on a country by country basis. And this is how on one dimension you have all the companies. And this again could be in a technology domain. So these are multi-dimensional charts that for the domain of water filtration, for example, these companies across the last 3 years have these many applications in these many countries. So you can imagine how many dimensions have been looked into to generate charts like this. So my PPT was done, but I wanted to also take everybody through to just one more presentation, not a presentation, but another report. This is an actual report that we generate. Is this presentation visible?
No, not right now.
Just one second. It would be now, right?
Yes.
Yeah, now it is visible.
Yeah, so this was an actual real life presentation that we had prepared for a company that was working in the PEF space, polyethylene furanoate. And so this is going to give a real life feel factor of how the reports get generated. So this is an exemplary table of contents. Then we give an introduction of what PEF is all about, PEF versus PET, advantages, applications of PEF, and what kind of companies are majorly doing PEF in a particular space. For example, in the biofuel space or in the bio-based plastic space, Avantium is one such company. And the client was more interested in understanding portfolios of these companies, and therefore we had analyzed them specifically. So this is indicative of how PEF-based, bio-based polymers have been sort of used in the last 10 odd years. So from 2009 till 16, how has the growth, what kind of companies? This is not patent oriented, but this is market research oriented data that we had identified. And then we had given, these are the objectives. That was the step one, if you remember, where we had defined the scope of the analysis, where we have mentioned, for example, that the objective was to understand the technology, prepare landscape accordingly, identify the major technology holders, identify their products, try to map their products to their patents and stuff like that. And like, for example, in the assumptions, we have mentioned that the landscape study only focuses on patents pertaining to PEF filed between these last 10 years, 5 to 15. With every chart, there will be an insight. This is indicative of the geographic filing trend. For example, most of the applications get filed through the WIPO, but on a country-specific basis, most of them are in the US, followed by China, and so on and so forth. 2006 to 15, this is the filing trend of applications. Top assignees are indicated here, as you can see, Procter & Gamble to Furanics to DuPont and so on and so forth. Number of applications have also been indicated. This indicates the publication trend of how many applications got published each year. Overall assignees, which were the top 10 companies, how many published applications they had. Number of published applications. So these are number of published applications. Again, this is another list of, so this is the second. So we've given 20. So those were these are the top inventors. So these were the companies, and these were the inventors within those companies that had the maximum number of applications which were published. And here we deep dive into the classification model. So we have said that this is the main chart, which indicates that most of the applications are in the classification of C08G. And this is further divided into these many taxonomy classifications, which are subclasses. This one is again bifurcated, this one is again bifurcated, and so on and so forth. So this helps the companies to understand which is the exact class. And the class is also indicative very clearly of the problem that they're trying to solve. Class gives the definition of what this C07D does. And within that, what is 49304 for? So even if you don't want to read the whole patent, but you can make a sense of the whole problem that they're trying to solve or the application that they have just from these subclasses as well. Then we've even done further analysis of every country by country analysis of the number of applications, and within the US, which companies have filed applications. So P&G versus Toray versus DuPont and so on. These are the trends that we are, for example, seeing in applications. So we've said that most of the bio-based PEF are being used for example, fibers and fibrous webs, or for bottles, or for disposable adsorbent articles, or for packaging products. Within that, again, which companies are the key companies? So that's the sort of analysis that got done. So within the disposable absorbent space, for example, any company wanting to use bio-based PEF would know that only P&G is the company that has sort of working in that space. And therefore, P&G is the only competitor that you really have to study patents of, for example. This is the mapping that we have done to patents. Now, for example, we've said, okay, Canon has this granted patent that talks about one type of PEF, which is the variation in dial components to get PEF or its derivative. Similarly, Canon has another application. This is of Novamont, this is of Toray. So again, when you do a deep dive into these patents, you will be able to understand what are they trying to claim, what is the core novelty of these patents. So here, for example, the patents are focused on variations in dial components. Here, there are different technologies to achieve PEF itself with the desired components. So now we come to, for example, company-specific analysis. This is Furanics, which was earlier called as Avantium. And then we analyze their portfolio, how many applications that they filed. They are in the recycling space, fiber space, PEF space, detailed analysis of what kind of patents are there. 72% of their applications are focused on preparation of PEF. And only 14% are focused on recycling. So basically, if somebody wants to prepare PEF agnostic of the application for which it is used, I think this company would play a big role there. And then the whole history of Avantium, what happened to the company, they got acquired by this company and so on and so forth. And these are the key patents of those companies, of that one company, Avantium. And then we have underlined the key aspects of what was the core novelty of their patents. Similar analysis was done then with P&G as well. As you would see, they are more product oriented. Avantium was more process oriented. Process, application and fiber. But if you look at P&G, you'll automatically see that they're more focused on the product being claimed, which is like the packaging material, disposable article. They're not claiming the process that much. And that is how analytics can help you understand what kind of space. So as you can see here, all the three applications that we have shown are disposable, absorbent, article, an apparatus comprising a flexible barrier package. So all of them are actually products that P&G is wanting to make rather than focused more on the process of making them. Similar analysis for Evian minerals, for Canon. Now Canon also, for example, is mix of process as well as composition blend. So if you look at it, this is a process application, reacting an acid compound with polyhydric alcohol and so on and so forth. This is a resin compound, but this is, for example, talking about the composition of that resin. How much of molecular weight does it have? What kind of temperature ranges would it work at and stuff like that. I don't want to go too much into the technical aspect, but I'm happy to answer on any aspect required. This is for Toray and similar analysis being done. So this is how we have mapped that this is the product of this company, of one of the entities, and this is how these are the patents that map to the product. So that also helps us understand how, for example, this application by IBM talks about generation of PEF, from PEF to high purity bottle grade polymers. And this is the process that they're using. Same analysis there. So we have analyzed multiple patents and indicated that, okay, foray into enzyme-based recycling technology. And Carbios is probably its product name or maybe the company's name itself, but these are the patents of this entity. And this is what it is trying to generate. So this entity is trying to generate monomers using enzymes of this nature. And that's the whole focus of this particular application. And then we try and show focus. So we say, okay, enzyme, and therefore a correlation that in 2015 they had filed this application, 15, 14, and in 15 they actually started production of its pilot plant in Saint Buzaire, France for biological process with capacity of using its exclusive enzyme-based technology. So analytics can very clearly help you map which patents are corresponding to which products, and you can very clearly get a sense of it. So if somebody knew about this in 2015 itself, they could have also done their or progressed on their research accordingly, rather than waiting for, because they have only started production in 15, but they would have filed this application maybe in 14 here, and maybe some indicators would have come through some other applications in 12 and 13 also. So if you keep a very clear tab on the IPs being filed by various companies, it will really help you in sort of making good judgment on what's out there and sort of use as much of material in public domain as possible. We had done some analysis of some university patents which were licensed to different companies. I don't want to go too much into it. These are some of the sources. Maybe I can show another report just to indicate, but most of the reports are around the same space. Just one second. Can you see another presentation now?
Yes,
we can.
All right, so this is another exemplary report on therapeutic contact lenses, TCL. Again, we've talked about what TCLs are. I'm just going to go very quickly through it just to sort of indicate. So again, contact lenses can be divided into rigid lenses, soft lenses. Soft lenses, again, these are all taxonomies. Applications, growth prospects, SWOT analysis. And then we come to patents. So here, so these are the strings that we run essentially. So these are the keywords, and these are the classifications. These are some of the exemplary strings that this is an exemplary string. And then we put it all together to say that, okay, we got 3,700 patents. And then we analyze all of these to arrive at these numbers. So 3,700 doesn't mean that all of them are relevant, but in the TCL space for a particular type of focus, we obviously within that 3,700 also numerous ones get filtered out. And then of the ones, this is the trend profiling. This is the trend on a country by country basis. This is the trend from a company perspective, what applicants are filing, the total number of applications. These are top corporate assignees. These are last 10 years of filings data from 2005 on a company by company basis. This is again analysis with respect to classifications. And again, this is how classifications are divided. So G02 talks about spectacles, but within that 00704 would talk about contact lenses. And then within that also, then you will have multiple other types of contact lenses, technologies used, and so on and so forth. So you can go as much into detail as possible. So of the final set of patterns that we had analyzed, we had defined that, okay, 123 of them focused on method or process related patents, 132 a product. And within the method of product, we had divided them into multiple companies. And then gone too much into the detail. Then we went into silicon, derivative, acrylic. And again, what are they trying to focus on? Some of them are on eye disorders, some of them are on multi-order disorders, blood-related disorders. This is another chart that indicates some applications, again, which are in the same space, which companies are owning, which kind of patents, what is the novelty being claimed in that patent, and so on and so forth. So these are the kind of charts. I can go on and show more if required, but I thought I'll take up some questions, and then if further elaboration is required, I'm happy to explain that. But just one more chart that we can go through perhaps. This is the analysis that we had done for this company called, this was not a project that we had done for MasterCard, but we had sort of done this analysis for an entity that wanted to understand the portfolio of MasterCard. This is the quick background about MasterCard. What does it do purely from a patent perspective? And so this is the whole division of taxonomy of MasterCard. So 35% of their applications are on data analysis management, 11% is on loyalty generating and spending mechanisms, 15% of focus is on authentication, and so on. And then within that, we went into identifying what are the key patents in each of these domains, and within the data analysis. So this is the second level of taxonomy. Within data analysis, 31% of their applications pertain to tax transaction data. And then maybe, for example, 11% are on consumer financial, personal financial data. Generating social graphs and connections is for another 4%. This is the second level of, just 1 second, let me. These are the key patents with the key feature. This is for the second taxonomy of transaction processing. So within transaction processing, 26% are based on payment status and decision making, 13% is on contactless payment, and so on. And these are the key patents. Within the key patent, these are the applications, these are the novelty areas. And then we do this for all the taxonomies that we had identified. And these are top inventors, these are classifications, these are mapping. So this is how we have mapped this patent to this product of MasterCard. Again, another patent application being mapped to this particular tracking a lost card feature of the MasterCard software, and so on and so forth. So this was again more exemplary that I wanted to show you. This is not confidential, and therefore I thought I'll share it accordingly. So I think I'm done, ma'am. I would leave it to the questions now, and happy to answer questions in that space.
Okay. So you have any questions, participants, regarding, in case anybody is interested in using the patent data? Tarun, your specialty is in patent data or other IP data also?
I mean, we are a team of 200 people. So, I mean, I handle the firm mainly, but my core focus is on strategy, more on litigation issues.
Okay, no issue. The people in your company, I mean, they look after other type of data also?
Yeah. And
Okay,
in fact, if there's any question on patent law in general, or any patent practice, anything on intellectual property, even trademarks or copyrights.
Maybe litigation. I don't think they have been exposed much to litigation and infringement as a session, in fact, but of course they know about it. So if anybody is interested, you can also ask on litigation, infringement, it's the procedural parts, some specific examples if you want to know in detail. So Mr. Tarun is open to that. Okay. Participants?
Yes, ma'am.
You all have any question? With Mr. Tarun, he says he's also open to litigation and infringement issue.
Anything at all. In fact, if they've got doubts from the previous sessions, anything of any nature.
Yeah. So you can please ask, because he comes from a practitioner background. Okay, Tarun, I'm reading out the question. One of them have raised it. Please explain if two companies get patents on same or similar product. So how this problem can be resolved?
So that depends on the claimed subject matter of the two applications. To what extent is it overlapping, in what countries have they got it? Now, but for example, if I and another professor in IIT Delhi are doing research on the exact same problem and coincidentally file the application on the same date with largely the same claims, because both are both are genuine in the sense that there is no wrongful obtainment case under 25(1) of the Indian Patent Act, then both of them will get the patent granted and both of them will have equal rights to their respective patent applications and granted patents in that sense. So, in fact, even if I file a patent application which does not get published, by the time the IIT professor files an application, same is the case, because he will, my application by virtue of not getting published will not become a prior art for that application, and therefore he will also get the rights unless the claims are exactly verbatim the same.
Any more question? Yes. Is in market Apollo tires with trademark and Apollo hospitals? What is the question? Who's VB? Can you make your question clear? What do you want to know actually? Apollo tire and Apollo hospital. Are you talking about trademark?
Maybe she's wanting to understand how can the two companies with the same name coexist.
Yes, ma'am. Yes, ma'am.
Okay.
It comes under infringement.
So it does not automatically come under infringement, sir, because both of them are completely different classifications. The classification of a hospital is completely different. It's a service, and
different sectors.
Classification of the tires will be under a very different class all put together. However, if there was one company, for example, that came in 1950s and became a very well-known name, and then there is this one company that came up which was a startup and sort of started using their name, then they could have initiated. But now that both the companies are renowned and big and big in their respective sectors, you can't do. But if tomorrow somebody comes up with a hospital with the name of Google, with Google being given the well-known status, acknowledged as well-known in the name of Tata, for example, or Reliance for that matter, you can't really come up with a bottle tomorrow and say, okay, I have Reliance bottles, because that is going to clearly correlate. But at the time when these two companies coexisted, maybe if Apollo Tires was the previous older company, they could have taken an action at that stage. But having allowed them to coexist for 3-4 years makes them completely lose all the rights to claim the well-known status after that. And with the classes being so different, there is no confusion to the customer also.
Okay, sir. Okay, sir. Thank you.
Okay, then there's a question from Salja. She's asking, please explain the legal point of view on author's claim on their work. If the story is made into film or drama with few changes in storyline, or even in folk songs been made into rock songs.
So, I mean, if the rule of law is very clear there. There are many precedents in that sense. There was a case of Hemabandhu versus the state of Hyderabad, Doordarshan, many cases in that nature where it's been very clearly held that if the public perceives that the derivative work or the adaptation that has been done, Hindi to English, English to Hindi, folk song to a rock song, whatever, if the public perceives after having a look at both the works that the second work is a derivative or an adaptive or an adaptation of the first work, then it would be construed to be infringement. So if somebody reads a book of Chetan Bhagat and then watches Three States or Three Idiots, whatever that Two States movie, and can very clearly draw correlation between the two and can say, okay, this had to be correlated from there, then obviously there is no question of not being infringed. Then the author can have all the rights. But again, you also have to understand that authors have limited rights when it comes to publications, because when you write a book, the rights for copyright usually go to the publisher. So you in the capacity of being an author may not be able to file a suit, but that depends on the agreement that you have with the publishing house.
So do you have, in case author is unknown?
If the author is unknown, you are saying, then obviously any aggrieved party, if he says I am the author, he will have to prove that he is the legitimate owner and creator of that particular work, which is the reason why I don't know if there has been a session on copyrights or not, but copyrights are implicit rights. You don't have to register them. But if you do register, then is only when you will be able to easily prove that this work was actually created by you. Otherwise also it will be a copyright that you will have, but how will you prove it? So if you write a book in 2015 and somebody copies that book in 2016, but it's not really a book, but a bunch of papers which you haven't really registered with the Copyright Office, how will you prove that you had written them in 2015? And which is why the whole purpose of registration of a copyright comes into, so that you can prima facie prove that the ownership of that particular work is with you. And therefore, if you are an unknown author or if you're an author who is not registered, you will have to first of all prove that you actually created that work. And once you do that, then you can claim your rights onto the infringement aspect. Yeah.
Okay, another question is how companies decide about the amount, that is money, for which they file the case related to infringement?
There are two bases for it. One is the extent of loss that you have happened, what extent of loss that you have incurred because of the other guy making profits out of it. So that's called the account of damages. That is one way that you can take. So you can say that, okay, by virtue of my technology and the infringement that this company X did, he made 5 crore rupees last year. And here is the proof for that, maybe from his balance sheet or PNL or whatever. That's one basis to raise an amount or claim an amount for damages. The second is that I would have made these many profits if this guy would not have been infringing on my technology. So either lost profits or account of damages that the other party gets. So these are the two ways by means of which you can claim damages.
Great. Okay, some more questions are there. Okay, I missed it out, I think. I was seeing some other question this side. Some people are not able to chat. It is in relation to the previous question about a movie being made and folk song where it was mentioned. So it says, can such folk songs be listed in traditional knowledge library?
So TKDL, which is Traditional Knowledge Digital Library, being talked about at this moment, I think only limits itself to herbal compositions or biodiversity related applications. And therefore, folk songs of any nature will not be construed to be a part thereof.
This will come under TCE, traditional cultural expression, although there's no particular law even at the global level. But I think they did not touch upon this TCE, traditional cultural expression, which comprises of songs, dances, performances.
Sure.
Okay. Another is, there's one more question I think I saw. 1 minute. Oh no. So any more question you want to raise? Or should we call it a day for this session? I don't see any question. colleagues, please ask as much as you can, because you see, you are lucky to face a practitioner. This entire FDP has been a mix of people from technical background, economic background, management background. So this gentleman is from, he's a practitioner, he has a practitioner base. So what he will tell you will be different, a little different from what academicians will tell you. Nothing. So actually today they have their exam. I think they are more worried about it. Anyway, Tarun, it was very enlightening, and it seems you are into too many things. And what I say as an academician from my side is, what you are doing is actually can lead to a research area of geography of innovation we can locate.
Sure.
By virtue of the inventors and the firm's area of work. So that's wonderful. But I would love to know if there is any free software by which we can do patent analytics, but they come with restricted property, isn't it?
That's correct, ma'am.
All the facilities are not there.
That's correct. That's correct.
Okay. Thank you so much, Tarun. It was very interesting, and I think everybody liked it. They are giving compliments also. Hope to see you again in future.
Thank you very much for your time. A pleasure, ma'am. Thank you.
Okay.